Welcome to the Rob Call Bottom Up Show, available on Progressive Radio Network, Pacifica Radio Network, Stitcher, SoundCloud, iTunes, and more. My guest for this show, a return guest, is Paul Hetznecker. He's a defense attorney who has devoted his professional career to advocating for the rights of his clients inside the courtroom. He affirms his role as an advocate, saying, "Advocating for my clients, I serve as one of many guardians in this watch over the power of the state, protecting the rights guaranteed under the Constitution, one client at a time." He's president of the board of the Defenders Association of Philadelphia, which is the public defenders organization for Philadelphia. He's also currently an adjunct professor in the Sociology, Anthropology, and Criminal Justice Department at Arcadia University, where he teaches courses in criminal law and procedure, civil rights, and surveillance. He's also taught at Haverford. His website is pauljhetznecker.com. That's HETZNECKER.com. So it's great to have you back.
Rob, it's great to be back. It's always an honor to be with you on your show. Well,
I feel the same way. You're one of the justice heroes that I think of. I think of people who really take a stand for justice. And I called you the other day because with all the protests going on, I knew that you were going to be involved in some significant way, and you are. So we're going to talk about that. So
sure.
The first thing I want to talk about is something we discussed last week, which is your take on looters. And you told me that you worked to persuade a group of attorneys to represent the people who were charged with looting. And I'm just summarizing it very briefly. Tell me about what that story is.
Well, sure. There's a little bit of a background to this. I have had the great fortune of representing protesters throughout my career. In addition to my criminal defense practice and civil rights practice, I have also represented protesters since the time I left the public defender's office several decades ago. So one of the things that I've always been very a strong advocate of is not only pro bono representation of protesters, but integrating political strategies into the courtroom and in the defense of those cases. So I was one of the key organizers and strategists for the RNC defense of the RNC 400. There was actually 420 people arrested during the Republican National Convention in 2000. About 420 people were charged. We won over 90% of those cases. Throughout the time that I've been in private practice, I've represented animal rights activists, anti-war activists, anti-death penalty activists, environmental activists. And then when Occupy came along, again, I was one of the key lawyers in Philadelphia, organizing the other lawyers, a group of really dedicated social justice lawyers, in representing the groups of individuals that were arrested during Occupy Philly. And there were 4 mass arrests, and we won all 4 of those cases. During the DNC in 2016 in Philadelphia, again, I helped, along with many other lawyers, organize a group of lawyers to represent those who were charged during the protests. And there's a fascinating story behind, what the city did with respect to those cases. And so I did that as well. So coming into the Black Lives Matter movement protests in June, I reached out to a number of my colleagues. Several of them had worked with me during the defense of the Occupy cases, and said we need to get lawyers together and represent all of those and coordinate it with the public defender's office, all of those arrested and charged with the various offenses during this social unrest and rebellion. And I call it a rebellion because I think, if we look back at the history of the civil rights movement, we see, not only are there significant Supreme Court precedents marketing the development and the expansion of civil rights and protection of civil rights, and we see landmark civil rights legislation, the Voting Rights Act, the Civil Rights Act, the Housing Rights Act, all those acts that essentially reaffirmed legislatively rights. What we don't always do, and we don't often enough, is reclaim the history and the origins of those significant precedents and legislative decisions. And they always go back to the movements themselves, the progressive, grassroots, political, and social justice movements. And so my view, just like I think most historians would look back and say, look, the tumultuous struggle for racial justice in this country, we can't ignore the chapters of strife and political and social and economic strife that were reflected in those events that occurred in Trenton and Newark and Detroit and Philadelphia and throughout this country during the 1960s, the late 1960s.
What events?
So,
what strife? What events are you referring to?
I'm referring to, Rob, those incidents that the federal government has classically called riots, and I call social justice rebellions. Those situations where in Watts in 65 and Newark and Trenton in 67, in Detroit in 67, and Philadelphia in 67, and those places where there was social upheaval over the long historic oppression, racist oppression in African-American communities. And the response to that oppression wasn't just, hey, we're satisfied as a nation with the Voting Rights Act and the Civil Rights Act and those legislative measures and those Supreme Court decisions. No, we're not satisfied with that. We want justice. We want economic justice. We want equal justice. We want to be treated equally under the law. And so I see those events in our history as significant politically because they represented the racist society and its oppression on African Americans, and then the corresponding rebellion against it, a critical rebellion, an important rebellion that really focused this country on the Black nationalist movement and the Black Power movement coming out of that era. And that had a significant, we seem to downplay that in the way we review and survey history, but that had a significant effect on white society and the racism in our society, because it was representative of a greater, larger quest for social and racial justice across the board, not just recognizing certain political rights, not just recognizing certain social rights and access, but recognizing that there is a caste and class component to our racist political and economic structure. So
go ahead, finish.
No, I saw the events in Philadelphia, for example, as reflective of certainly an opportunistic circumstances for many young people. But when we surveyed the cases after the arrests, there were 650 felony charges in Philadelphia. Of those 650, I think 238 individuals had no prior record. No prior record. So that meant that the events that occurred in and around Center City and in West Philadelphia and other neighborhoods where there were burglaries of commercial establishments. There was theft from those establishments, and I'm not justifying the crime, but I think it's reflective of the greater oppression that exists in African American communities, that economic oppression that's long been written about and discussed. And I think for many young people, this was a crime of opportunity, but it was also a reflection of the deeper chasm that we have economically in our racist class and caste system. And so my position was for those lawyers that wanted to represent protesters, and only protesters, because they wanted those cases that were in their minds pure speech or pure issues of political statements and suppression by the police department and the state police of those political statements. They were looking for the classic protest cases. And interestingly enough, those classic protest cases in Philadelphia have been decriminalized. So prior to the Democratic National Convention, so let me back up, for years, we would represent, we meaning us, that stood up and said we want to represent those people charged, progressive movements, progressive individuals charged with the various offenses related to their First Amendment expressions. And those offenses generally fell into three categories. Obstruction of the highway, which is a misdemeanor under Pennsylvania law. Failure to disperse, which is also a misdemeanor under Pennsylvania law. And disorderly conduct, which is a broad statute that's adopted in almost every state. It gives police unfettered discretion to make a decision on the street as to how to undermine somebody's liberty interests. So they kind of determine how the statute applies under the broad language. Those three statutes were classically charged in most all of the cases, protest cases that I had been involved in through the decades. June of 2016, city council in Philadelphia got clever. And what they did was they took the language of the three statutes and they put it into a city ordinance, essentially a civil penalty, a fine. They decriminalized protesting. It didn't stop the arrests. It didn't stop the gathering of political intelligence by the local police department shared with the federal government, because people were arrested, they were zip tied, they were removed from the scene, and they were issued citations. But it ended the criminal prosecution of protesters in the classic protest cases.
That's a good thing, right?
It's a good thing. It's a good thing. But the reality is, Rob, it's an effort to undermine the First Amendment regardless. And so when we tried those RNC cases back in 2000 and 2001 and 2002, what we did learn, because we had the benefit of the full panoply of criminal procedural rights. We had the right to discovery. We had the right to Brady information. We had the right to hearings, motions to suppress. We were able to gather a lot of information in that pretrial process of the extent to which the police forces had undermined and infiltrated protest groups in advance of the RNC, the Republican National Convention in 2000. And we won a lot of cases based on that information.
Were they acting as agents provocateurs?
Well, that's a good question. I mean, there were certainly some of us that believed that that's exactly what was happening. There were four. So there's another historical chapter here. 1987, I was a third-year law student at Temple, and I was a member of the National Lawyers Guild, and I was a legal observer at a large anti-interventionist march. Vice president at the time under Reagan was George Bush, the first, the elder. He came to Philadelphia and was going to give a speech at Independence Hall. At the time that he was giving that speech, the march that I was a legal observer of ended up at the corner of 6th and Market, right in front of the courthouse, the federal courthouse, and right in front of 250 yards from Independence Hall. I negotiated with the Park Service, with the police, an area which the protesters could then be seen visibly, but would be about 300 yards, 250, 300 yards away. After that was negotiated, the police, Philadelphia police, moved the horses in, both the wooden horses, to block off the protesters and essentially corner them off in a particular location. Then they moved in the real horses, and the mounted police came in. They made 4 or 5 arrests. I referred those people to a civil rights firm that I was very friendly with. And out of that lawsuit, there was a revelation that, in fact, Philadelphia police had infiltrated the protest groups. And so there was a ban on that infiltration. There was a consent decree, and the agreement going forward, Philadelphia police would no longer infiltrate protest groups. Right. Fast forward to 2000, well, that was good, except fast forward to 2000, the state is always clever. The law enforcement's clever in their maneuvers. Fast forward to 2000, when the puppet space was raided by the Philadelphia police at the behest and in conjunction with federal intelligence gathering and state police infiltrators. In fact, the way to get around the consent decree was they sent state troopers in. So the state troopers were the infiltrators. The state troopers were the alleged agent provocateurs. And we outed them during the course of those pretrial hearings. So the infiltration of protest groups is long and storied. It went back all the way through to the labor movement in the 30s and 40s, even before that, in the early 1900s. But through the 30s and 40s, the labor movement into the civil rights movement, COINTELPRO, there have been examples over and over again of law enforcement using infiltrators to gather police intelligence on protesters, on people exercising their First Amendment rights. So, for example, during Occupy in 2011, what we discovered was that there was an FBI poll camera outside the encampment that had been placed there during the 43 days of occupation. We also found out that they had activated, I found out through a FOIA request, that they had activated a confidential human source, which is considered an infiltrator in parlance of protesters. In the parlance of FBI, it's a confidential human source. They activated this person to infiltrate the Occupy Philly movement, and that was done before the movement even began its first meeting. So there's a long, long history of infiltration and undermining First Amendment rights, both blatantly, at the end of a baton, a police baton, and with brute force, but also covertly by use of political intelligence gathering, not just through surveillance of now public source information, but cell phone information, as well as with direct human contact and human intelligence gathering with infiltrators.
Well, I guess with the resources of NSA now, which can tap into every phone, every email, it's much worse than it's ever been before, too.
Well, one of the things that, I have a pretty active practice, federal practice for many years. And one of the things that over the course of the years that we've seen law enforcement, FBI, Homeland Security, and other agencies utilize in the criminal investigations are exactly those kinds of efforts and that kind of technology. Of course, legitimately they have to seek warrants under Title III. But with protesters, if they're gathering the information and they have no intention of revealing that they've gathered this information, access to the technology now is essentially is so easy for law enforcement. In fact, the technology has outstripped the protections under the law. So much of this is not in violation of the Fourth Amendment, given classic Fourth Amendment law or current Fourth Amendment law, which has become a tattered rag with no protection at all. But under the First Amendment, there's good argument that gathering this information, this associational information, this expressive information, this information that people are sharing in an effort to raise their voices in dissent on whatever issue, gathering that information is violative of the First Amendment. And so that's a second front that can be utilized in attacking this police state incursion.
Now, there's talk just today about how journalists are being tracked and they're trying to tie them to other countries and things like that. So how is this a violation of the First Amendment, tracking journalists or tracking protesters?
That's great question, Rob, great question. So classically, and I'll refer to our former friend, Cheryl Byron Wright's case, where she was arrested by the police.
Well, let me just background. Cheryl was an editor at opednews.com, my news and opinion website, and she was covering a protest against an ROTC center in Philadelphia, and she took pictures of police arresting the protesters, and you take over from there.
No, that's right, Rob. And through you, I actually met Cheryl, and so I was very honored to meet her and then subsequently represent her. So they arrested her along with the protesters. The protesters, I represented those 6 that were arrested. They were acquitted. But in Cheryl's case, I provided the credentials to the DA's office, her press credentials, which resulted in their decision to obviously decline the charges. She was there to cover the event. Fast forward, what we found out through information that was leaked to the press inadvertently by the Pennsylvania Homeland Security chief, which resulted in Governor Rendell firing that chief. What we learned was that a think tank, a right-wing think tank based out of Philadelphia University, 2 former agents, one of Israeli intelligence, had been gathering information, open source information and other information on protest groups throughout Pennsylvania, providing that to Homeland Security. And that open source information was often couched in the terms of the label of a national security threat. And so a lot of it was related to the anti-fracking movement, and this is going back 10, 12 years ago. But some of the organizations, there were about 300 individuals and organizations that were listed. And many of those organizations, like the ACLU and the Communication Workers of America and the American Veterans Service Committee, they were longstanding progressive organizations, not a threat to national security, not in any way, should in no way be on a watch list for anyone's concerns. Among those listed was Cheryl Byron Wright because of her arrest during that protest against the Army Experience Center up at the Franklin Mills Mall in Philadelphia. So it does have a broad chilling effect on journalists. I think there was an effort in Pittsburgh around the same time to investigate or to provide or get information regarding a journalist. Journalists have been excluded by police action on the scene when they're trying to cover the event for the benefit of the general public, as is the obligation of the fourth estate in our democracy. And there has been a lot of attempts by the government to undermine journalist rights. So the critical to exercising a significant, vibrant discussion on any issue protected under the First Amendment is the right to know, is to have the knowledge and have that knowledge disseminated by a free press. And so certainly incursions and attempts to undermine the free press, which we've seen certainly under the Trump administration routinely, that kind of threat to our democracy is an important one that we have to take note of and fight back against.
But my
journalists,
understanding was, from what you said, that it's a violation of the First Amendment to be tracking people's communications like that.
That's my position. That's absolutely my position. And unfortunately, we don't have a lot of good case law on that, but there are cases that support the notion that the government can track for various reasons. So, for example, when I filed a lawsuit under FOIA against the FBI, the NSA, and the CIA for conducting what I believe to be surveillance of the Occupy movement, that essentially that use of intelligence agencies and the power of the intelligence agencies to say that we are not in violation of the First Amendment. We are actually investigating a potential terror threat. We're investigating a potential criminal association. And when those exemptions to the FOIA, for example, are invoked, it's a way in which the government can prevent the abuses of power that we've long seen and have been revealed over the course of many decades, many times over. First, during the COINTELPRO examination and exposition by the Church Committee, then later on, obviously, by Snowden's revelations, we have seen, and Watergate was another example, where we've seen long-standing abuses of police-state power using the power of surveillance available to them in violation of sometimes directly the Fourth Amendment, but certainly the First Amendment. We should not be a coward. We should not be undermined. Our associations, our discussions, our decisions to express our points of view should not be subject to tracking by the federal government or by any government, by local, state, or federal agents.
How do you fight it?
What's that?
How do you fight it?
Well, I think you fight it on a number of grounds. I think one of the things that's fascinating, I represented an animal rights protester on appeal. I did not try the case, but I represented him on appeal in the Third Circuit. And one of the very dangerous and fascinating arguments, and this will be I'll set up my response to your question with this. One of the fascinating but very dangerous arguments was that during the course of the government's oral argument and in their brief, what they argued was that communication by this animal rights group, communication that was under surveillance based on warrants that were issued under Title III, communication that was encrypted, was deemed to be criminal. So they actually made the argument in the Third Circuit that because these protesters knew, these animal rights activists knew that they were under FBI surveillance based on Title III warrants, that their decision to communicate an encrypted email, which could not be accessed by the federal government, was intentional and intentionally criminal. Now that's a very dangerous, broad conclusion to reach simply because people are seeking private communications. So what I say about that issue is this: we have, unfortunately, we've inverted the paradigm. The paradigm in a democracy should be the government should be as transparent as possible so that the people can make decisions about the power brokers and the mechanics of power and how power is used and abused. It should not be the other way around. We should not be in a position where we have been stripped of our privacy rights. And the government says, if you don't show me everything that I want to know, you must have something to hide. Therefore, by the virtue of your seeking privacy, by the virtue of the fact that you're seeking to communicate privately, you must be hiding something dangerous from the government, and therefore it should be barred. This is precisely the reasoning behind the legislation that allowed the federal government to tell the telecommunications industries that whatever technology they developed, it must comport with the government's ability to reach it, to access it, whether it's an iPhone, whether it's an Apple computer, whatever it might be. So when the legislation was passed in 1986 and then later on amended, the whole purpose was the government wants to make sure that whatever communication in this post-industrial world is created, whatever means of communication is created, that the government, when they have the authority to do so, and sometimes when they don't, they want to be able to access this. So that's the danger, and the way to fight against this, Rob, is on the legal front, but also with our minds, with our creativity, with our feet, with our voices. So we shouldn't be cowed or chilled in our voice against this emergent corporate power and this very dangerous anti-democratic process that we've experienced over the last 40 years of eliminating local voices, of eliminating and usurping our democracy with powerful corporate interests. We need to fight back with local, strong First Amendment voices of dissent. And whether we're tracked or not, we got to exercise those rights. But in the same way, we have to try to protect those rights. So encrypted email that people engage in is a perfectly legitimate way to communicate.
And that's something that has been encouraged by many journalists. Snowden inspired it, and Glenn Greenwald and The Intercept, they all have systems so that people can communicate with journalists. We need to take a brief show ID, so we'll do a pause now, and then we'll come back. I want to keep talking a little bit more about the people who were arrested for looting, because you've still got more of a take on that I want to hear about it. So we'll pause.
Sure.
My guest for this show is Paul Hetznecker. He's a defense attorney who has made his career, not his career, but he's spent a lot of his life defending protesters and fighting for justice. He's the president of the board of the Defenders Association of Philadelphia, which is the public defenders organization for Philadelphia. And he's an adjunct professor in the Sociology, Anthropology, and Criminal Justice Department at Arcadia University, where he teaches courses in criminal law and procedure, civil rights, and surveillance. So I want to hear more about these people who looted stores. Like you told me about like kids who would go in, steal sneakers, and they didn't fit them, so they just take them out of the store and throw them on the ground.
Yeah, there was a lot of that. There was a lot of spontaneous, kind of unexplained activity, frenetic activity, almost like this was an opportunity to break the barrier of the norm of the existing structure of exclusion, and exclusion meaning most of these items in poor communities are not available just because they're to most people because of the prices. So a lot of it was just a reaction to kind of the economic conditions that people are in, and I think we can't overlook that. I mean, we can't somehow deny it and say, yeah, are they crimes? There's no question that they're crimes. But here's the other part of this: a lot of the people that were arrested never went inside. So there was a whole group of people that are factually innocent of the crimes of burglary. They never went inside. They were arrested because they were outside, because they remained outside, either watching or gaping on what was going on. So there's an issue of proof with respect to a lot of these cases as well. But for those that were inside or caught inside, the act of representing those individuals at a time of great social unrest who were charged with burglary of a national chain that has overpriced items inside of it, outside the reach of the general neighborhood and the community, that's a significant political statement by us as lawyers, as it is overall in terms of the movement itself. Because we have long been participants and spectators in this ever widening chasm between the rich and poor. When I say participants, I mean we're all a part of a process in which we have seen this happen. And we feel very not empowered to do anything about it as a society. And I think in some ways, the elections become almost a surrogate for that powerlessness, but doesn't really empower us in the way that we need to empower to make significant, dramatic, structural social change. So we can vote in Joe Biden. We could have voted in Bernie Sanders or Elizabeth Warren. But Elizabeth Warren, despite her strong anti-corporate stance, which is very powerful and very compelling, despite Bernie Sanders' strong anti-corporate stance and support for workers, which is very powerful and long-standing, neither of those political platforms are going to change the structure of a corporate society that's reinforced the widening gaps between those who have and those who don't. And so the ballot box becomes a surrogate for many of those social issues. And for a lot of the left and the progressive left for years, who felt outside of that process because there wasn't any room in the Democratic Party for the political progressive left. There really wasn't. The broader issues became the mantra upon which the system was legitimately attacked and critiqued. Now we have a very different kind of movement that's occurring. It's a number of different social justice movements. We have the manifestation of the Occupy movement, which really, I think, fostered the candidacy of Bernie Sanders. I think Bernie Sanders was symbolic of a significant shift in the political mainstream to the left, and in the Democratic Party at least. And that was something that never happened in my lifetime. I'd never seen that before. I always stood outside of the system as it existed within the Democratic Party, and still remain independent of the Democratic Party because of my political and ideological views. But for the first time, Bernie Sanders in 2016 represented a progressive voice, a powerful progressive voice, getting masses of people out in support of him, primarily young people, which was also significant. And that, I think, social movement has a ripple effect, and has had a ripple effect throughout the course of the last 4 years. Likewise, the Black Lives Matter movement was labeled a terrorist organization, a terrorist movement back in 2016 by the federal government. Now it is embraced widely because of the great unrest and protest and
Wait a second. You just said BLM was labeled a terrorist movement by the federal government in 2016?
Yes. And in fact, I'm about to file a FOIA request on behalf of a Black Lives Movement activist in which I've sought FBI documents regarding this request. This has been already been revealed that Homeland Security and the FBI had considered the Black Lives Matter movement stemming out of the events that occurred in Missouri after the killings of African-American men throughout this country by police. And so out of that, it was labeled a terrorist organization, or viewed as a terrorist organization. So
by Homeland Security and the FBI?
Yes.
Wow. What do you think? You know, I'm still not done with these kids who stole stuff.
Understood.
Now, you started this conversation by saying that there's like a kind of a historic precedent, like what took place in Watson, Newark, and Trenton. Is this a kind of precedent that could be used in court to defend these kids?
Great question. It's a great question. So one of the great challenges for every lawyer who represents activists, revolutionaries, as I have represented, political progressive organizations, every lawyer is faced with the challenge that the law puts on us as criminal defense attorneys in terms of what defenses you can put on and what you can't put on. So, for example, during the Occupy movement, we raised First Amendment defenses for a number of those mass arrests, and we won them. We also raised a justification defense in one of the cases before a jury, and we won that case as well. So,
what do you mean a justification defense?
Well, I'll tell you. During the 4 mass arrests, one group of individuals, activists, were arrested inside the Wells Fargo bank, a bank branch in Center City, Philadelphia, and going to trial. They didn't disrupt the actual conducting of business inside the bank, but they were very vocal inside the bank, and they sat down and they protested. And what they protested was fundamental to our notion of our concerns about our democracy. That is the vast power that Wells Fargo Bank has over lending decisions, especially in minority communities. So the predatory lending, they challenged the predatory lending. They made pronouncements about the racist redlining and essentially the undermining of equitable decisions made for those who were seeking loans in minority communities, African American and Latino communities. And as a consequence, we put that defense on in front of a jury. We put that defense on. We had our clients testify in great detail about what impact Wells Fargo's policies had on the communities of color in Philadelphia and the racist predatory lending that had gone on for decades in Philadelphia, and in particular for the years in which Wells Fargo had branches here in Philadelphia. So that evidence was placed in front of a jury, and that became part of our argument, a quilt of arguments, a plethora of arguments that intertwined the First Amendment on private property, and we argued that it was acceptable under these circumstances as a very creative argument. As the public spaces are colonialized, as the access to power becomes smaller and smaller because it's less democratic.
Wait, public spaces are colonialized?
Yes, public spaces have been colonialized by, for example, the decisions by the courts regarding malls. So the mall is not considered the public square, and therefore a mall owner, as with the case that I tried for the protesters in the Franklin Mills Mall, they were admitted into the mall. If they had been told by the owner to leave, he had the power under the law to exclude them and deny them their free expression, constitutional rights to express them. But once they were let inside, and once they were allowed to express their opinions, and the counter demonstrators inside the Army Experience Center expressed their own views as well at the same time, then it became, in my view, in my argument, it became a First Amendment issue. And then it became a question of content-based discrimination by that employer who decided to let one voice in and let one voice express itself and not the other. So it became a complex quilt of arguments regarding what becomes private space, now colonialized, public space is now colonialized by private entities like a mall, the village square replaced by the mall, which the law doesn't protect First Amendment rights. But if you allow one group in and not the other, then now you have a First Amendment issue, Judge. You're now going to contend with content-based discrimination. So that was one of the arguments. The other argument with respect to Wells Fargo was the expression inside the bank was essentially consumer information. So they were providing consumer information to the customers that came to the tellers centers asking for money or asking to withdraw money. They had the right to express, as many of those activists were, had accounts with Wells Fargo. They had the right to express their view about the way the corporate decision makers had used their power in a racist way, in a predatory way in Philadelphia. So that also became a part of our First Amendment argument, that once they were inside and once they were inside expressing themselves. Now, would we have won that on appeal with an appellate review? Who knows? But it was an argument that we made and the judge allowed us to make in front of the jury in conjunction with the justification defense. And the justification defense was based on all the information that our clients testified to regarding the power that had been abused by this corporate entity in the way it had issued loans or denied loans. And that became something that the jury could consider in a justification defense, an instruction which the judge gave on justification. So that was an acquittal across the board for all 12 members. And we have to be creative as progressive lawyers. We have to be creative as radical lawyers. Because in large part, what was radical yesterday becomes reasonable in the face of injustice today. So if injustice is something that is expressed and is able to be communicated in such a clear way, the jurors, the judges, those around us, our society in general, starts to look at, for example, the Black Lives Movement in a very different way. So as labeled a terrorist organization, as a threat to national security, unlike these white supremacist organizations that don't seem to fall under much scrutiny by the federal government at all, the Black Lives Matter movement considered a threat to national security. Well, what happened in June of 2020? What happened in June was an explosion of consciousness. What happened in June was a recognition that the fundamental racist caste system in our society is no longer acceptable. And unfortunately, it was motivated by young people. It was motivated by a whole generation that threw off the mantle that had been carried through the status quo year after year, decade after decade, and it started a new dialogue over the quest for racial justice in this country.
Okay, and we need to take another break now. So a little pause. My guest for the show is Paul Hetznecker. He's a radical lawyer and defense attorney who has, over the decades, represented hundreds and hundreds of protesters and people who have been trying to fight for justice. And he goes into the court, both local and federal, and stands up for them. He's currently an adjunct professor in the Sociology, Anthropology, and Criminal Justice Department at Arcadia University, where he teaches courses in criminal law and procedure, civil rights, and surveillance. And he's the president of the board of the Defender Association of Philadelphia, which is the public defenders organization for Philadelphia. His website is pauljhetznecker.com. So, Paul, we've been talking about defending people who go into private property. I want to spend the last section of this interview talking about how you're going to defend these people who went into stores and took stuff. Are you going to defend them all? Are they all defensible, or are some of them opportunistic and some of them in a different category? Do you put them all together, or do you separate them?
No, they're complex layers to this, Rob. So just like anything, just as I was discussing the defense of protesters, it's all contextual. Every factual, as every lawyer knows, every factual scenario is different. You come with it with creative theories, and you chip away at the rock of injustice by coming up with creative arguments that will rue the day for your client. In this particular set of cases, as I said, there are so many numerous issues. There are people who were not inside at all that were arrested based on association. They were just grabbed up by the police. There were people that were arrested inside with property on their persons. There were people that were arrested inside that were just simply inside. And so obviously the argument is their intent was to commit a theft like the others who actually had property on their persons as they were leaving or caught inside. So there are a number of statutory arguments regarding the level of their involvement or lack of involvement. But there's another possibility here, which is this. Aside from those who are factually innocent, and if we can establish those cases, the innocence by video camera, by not only the private cameras of the stores, but also the public cameras outside, or other private entities that have had cameras outside. Besides the factual matters of who was inside, who was not, who actually committed the crimes of burglary and who didn't, there's another fundamental question, which is this. For those 238 individuals that had no prior record, whose involvement may or may not have fallen into those categories I talked about. They might have been outside and just grabbed based on association. They might have been inside and actually committed the burglary with property on them, intending to take that property, which is what a burglary is. It's the criminal trespass. It's the trespass without authority, without license, with the intent to commit a crime. And that's what a burglary is under Pennsylvania law. So for all the categories of individuals, why not get creative? Why not fashion a restorative justice model for those who are actually involved, that the district attorney's office can prove involvement, and allow for a restorative justice model that makes recompense and compensation to those storekeepers, those store owners, those businesses, but doesn't involve a criminal conviction. So we have diversion programs, as every system does throughout this country, and those diversion programs usually aren't tethered, except for the actual compensation that's required, the restitution, as it's termed, that's required. Why not create a restorative justice model that allows for those who they have strong evidence committed the crimes to go to those store owners and storekeepers and assist them in rebuilding?
And you have now, as Philadelphia's DA Larry Krasner, who in the past worked with you as a defender of protesters, probably the best person maybe in the whole country to be able to accept a proposal like that.
Agreed. And so we're in the process of reaching out. The group of lawyers that I was able to organize sent a letter to the district attorney in Philadelphia last week, and we're hoping to get a response from him in soon, in short order. We haven't heard from him. I have known him we started at the public defender's office together in 1987. I've known him for a long time. As you mentioned, we tried many of protest cases together. But he is now the chief law enforcement officer of the city of Philadelphia, and I stand on the other side of the room. I stand as every other defense attorney and every public defender, as Charles Ogletree has stated, as the last sentinels of the Constitution. We're not here to give any quarter to any law enforcement officer, whether it's a progressive DA or a fascist DA or whoever it might be. We are going to stand on behalf of our clients and protect their rights. But you're correct, Rob. If there was ever an opportunity with someone in office in an unprecedented position to do justice in a restorative way and creative way, certainly the DA in Philadelphia is in that position. So you're correct.
Now you drive around Philadelphia and you see signs on people's lawns, help wanted, replacement for Philadelphia district attorney. And you figure they're police people. I mean, the police hate him. I just wonder, and then during this last month and a half of protests, he actually charged two police officers, I think, with crimes for assaulting protesters. That just doesn't usually happen. Can you talk a little bit
No,
about that?
no, it doesn't. Let me just say, so let me make a comment about that, because I really need to expound a little bit upon this. First of all, you know, I should add that I'm also bringing, with a team of lawyers, the lawsuit on behalf of the 676 protesters, as well as the protesters and residents of 52nd Street who were attacked in a military-style assault by the Philadelphia police and state police on May 31st and then on June 1st on 676. So I'm a part of that group of lawyers, civil rights lawyers, bringing lawsuits against the city of Philadelphia right now. But let me make this point, because I think it's really important for everyone to realize. There was one system of justice in Philadelphia before Larry Krasner became DA, and that system of justice favored the police. For the last 30 years, and I've been practicing, this is beginning my 34th year of practice, no police officer except for one, until Larry came along, until this recent DA came along, had ever been charged with a killing while on duty, even though there had been hundreds and hundreds of police-involved shootings. And in fact, between 2007 and about 2013, there were almost 400 police-involved shootings, and not one resulted in a criminal prosecution. So the police have been given a pass for decades in Philadelphia, and they have been given the power to execute on the street with impunity. They have been given the power to violate Fourth Amendment rights with impunity, except for those judges who have been willing to stand up and vindicate the rights of individuals whose Fourth Amendment rights were undermined by granting motions to suppress. And there are a lot of judges that have been willing to do that, and a lot of judges that have seen through the years, seen through the fabricated stories by police officers to justify their searches. So the police culture in Philadelphia has been the dominant culture in the criminal justice system for far too long. All that this DA has done is balanced it out in some significant measure. That's what he's done, and that's what he's in the process of doing. And that's the way it should be. Police officers should not be above the law. FBI agents, law enforcement officers should not be above the law.
What do you mean balance it out?
Balance it out by saying, if you're going to violate the law, you're going to be subject to prosecution. So if you're going to strike a protester with a baton repeatedly over the head, that's an aggravated assault under Pennsylvania law, and you should be charged. And that's exactly what happened in the case of one. If you're going to grab someone's face mask, your goggles, and spray pepper spray into their face, that's a simple assault under Pennsylvania law, and as such should be charged, and that was charged. So those are the two police officers that you're referring to that have been charged criminally. And those criminal charges would have been levied against any individual if they weren't police. Why do we give an exception to police? And we've given far too long, as I said, a pass to police officers in the city of Philadelphia. And then crimes have been committed with impunity over the decades. And the DA's office traditionally has passed on prosecuting those police officers. And many of them who have been fired by the police have been able to get their jobs back through the arbitration process. And so we have those same bad apples, those same bad cops back conducting arrests with a gun and a badge, and essentially with license to continue to commit crimes.
Well, let's talk about the guy who sprayed the protester in the face. What do you know about him?
Right. Well, Nicoletti he's had a long, not a long career. He's 35 years old, but he's had a number of incidents that he has been noted for. And I'm not going to get into details because he's going to be subject to a criminal prosecution, obviously, and that's going to be something that the prosecution either is going to try to introduce or not. Certainly, the defense attorney is going to try to exclude. But let's say this: his family, his father, they're not unknown to internal affairs, and so the details of his background I'm not going to get into.
Okay. Okay. All right. But his father? Was his father also a policeman?
Yes, his father was a policeman, and there's open source information on his father's misconduct as well, and people can read about it.
Well, you don't want to get into that. Okay. So
it's not necessary to get into, Rob, it's not necessary to get into it because I've looked at thousands and thousands and thousands of internal affairs reports over the years. I've sued internal affairs in the past. What's happened in Philadelphia is not just reflective of one officer or two officers or a family history. What's reflected in Philadelphia is a long institutional a lack of accountability and lack of transparency by the system. So individual officers, individual cases, individual allegations are often unfounded or the officer is exonerated. But if you have 15 complaints against you in the case of one officer that I deposed last week, if you have 15 complaints against you and you're still on the force, if you have 10 complaints against you, all been dismissed, and you're still on the force, there's a problem with the system of investigating that officer, because those are 10 separate individual complaints from individuals completely unrelated to one another, and yet that officer still retains his job or her job. Because why? Because there's a system that reinforces that kind of conduct, that misconduct, over and over and protects the officers. We do not have a legitimate system of accountability in Philadelphia, and that's what needs to happen when it comes to officers. So singling out one officer over another is not really the point, because it's so ingrained in the institutional culture of the police department, and that's what's got to be the topic of discussion. That needs to be stripped away.
And that's not something that the DA can really deal with. That has to be dealt with by the police department, which gets its mandate from the mayor, I assume, right?
Well, this is one of the other interesting things that we're raising, in the context of our litigation with respect to the protesters and the residents that were attacked in this military-style two attacks, one on May 31st in the area of 52nd Street in West Philadelphia, and the other on 676. What we're getting to is the root of real reform. How do we get real reform in Philadelphia? Police departments are untethered, really, by the political structures that they're supposed to answer to. The mayor can fire the commissioner, but police departments are really the origin of their power comes from the state, and the origin of their power is unchecked. So they can create their own policies and their own procedures within the department, and you can create a civilian review board. But if it doesn't have any teeth, if it doesn't have subpoena power, it doesn't have the power to make recommendations that are actually followed, if it doesn't have the power to conduct individual investigations of individual officers, if it doesn't have that power kind of at the inspector general level, supported by community voices and a community board that has that power to strip away the layers of secrecy, if it doesn't have that power, then it's going to have no impact. So you can replace the commission.
I kind of follow Chris Robb, who is one of the legislators in Pennsylvania. He's a progressive who was elected, and he's been talking about how there's some new legislation that's going to track these police so that we can actually see and have available that information about how many complaints have been held against them. That could make a big difference. So you're saying this has to be done at the state level?
Well, it's got to be done at the state level, but there's a lot that can be done at the municipal level as well. So even the mayor could intervene with the support of city council to create a body that would have some teeth to it, to have some investigatory power to it. It would be up to the mayor and city council. With respect to the statutes that limit that power, that are state statutes, yes, and I'm not going to get into the details of that, but just revealing the backgrounds of police officers is just one step. It doesn't go far enough, because a lot of the police officers, for example, in Philadelphia, they're not going anywhere. They're coming back to their jobs in Philadelphia. They'll commit an act of misconduct. They'll be reviewed. They might be fired by the existing commissioner, but then they'll file for arbitration under their contract, as they have a right to do, and they'll get their jobs back.
Okay, so we've got 2 minutes left, and I really want to nail a couple questions down. You're suing the police, the city, the individual officers. Who are you suing? And are you suing for damages so that you get money for these victims?
Absolutely. They have a right to compensation for the injuries that they suffered at the hands of this brutal military-style attack, both in West Philadelphia on the 31st of May and June 1st on 676. We are suing for compensatory damages. We are also suing for injunctive relief.
Now, are you suing the city, the police department, the individual police? Who is going to end up being accountable? Is a cop who beat up somebody going to end up having to pay anything, or are the citizens of the city going to have to pay for that cop?
Great question. So just as a matter of procedure, we are suing, and a matter of substance in terms of who we're suing. We are suing the municipality, which is the city of Philadelphia. We're suing the police department, which is an organ of that city. It's an offshoot of the city. We're suing the mayor. We're suing the police commissioner individually. We're suing a couple of individual officers that have been named. And then we're suing John Doe and Jane Doe officers whose identities will be revealed during discovery. So those officers that actually fired rubber bullets at point blank range into people's faces, into their backs, into their spines, those officers that fired and threw tear gas canisters at people's faces, into their bodies and near where they were, trying to breathe and suffering with asthma, many of them, those officers that use pepper spray and sprayed people directly in their faces, each one of those individual officers has been sued as a John Doe or Jane Doe, and we will get their identities so that they are accountable through the process of discovery. Now, the question you ask about who pays for it, well, that's long been a difficult and significant issue. So the city of Philadelphia would step in and pay for those police officers, pay for their conduct. So in some ways, there's no accountability, even in seeking compensatory damages, because it doesn't reach into the pockets of the police officers, and it doesn't affect their right to even be continued to work as police officers. So one of the things we've had to say to our clients is, we're not going to get the police officers fired as a result of this litigation. But what we can do is we can make significant reform proposals that go well beyond the reach of the litigation. And we're going to ask the city to make those, to embrace these proposals and pass these proposals on to their clients. That is city council.
And we've got a wrap, and I want to just throw in, you mentioned Cheryl Byron's case where she was arrested for taking photos of police arresting protesters. Police now have a policy that they're not allowed to do that anymore. And I'm certain that your prosecution, your litigation helped to make that happen. Cheryl suffered. She was put in jail and stayed in overnight, but now they can't do that anymore. And so that's another way, besides the monetary damages, that you make a real difference. And we've got to wrap. Paul, thanks so much for being here. You've been listening to Paul Hetznecker. He's a radical lawyer and a defense attorney. He's a lion of justice, Lion. His website is pauljhetznecker.com. And Paul, thanks so much for all you do.
Rob, thanks for all you do in disseminating significant information to the public about what social movements and political movements are doing in this country. That's number one. And number two, it's always an honor to be on your program. We have known each other now for over a decade, and I really treasure the relationship we have, and I really laud the work that you do, and I hope that you continue to do this work on behalf of the public and on behalf of our democracy for decades to come. Thank you, Rob.